Good afternoon. Welcome to the CLE hosted by the Minnesota Alumni Network. I'm Megan O'Rourke, class of 2010, and a member of the Alumni Network Board. I'd like to share a few housekeeping items about our CLE today, and then I'll introduce our presenter. First, today's webinar is being recorded, and the link to the recording will be shared via email following the event. We have live captioning enabled. You can click on live transcript feature at the bottom of your Zoom screen to view or hide the captions throughout today's discussion. And we'll do our best to reserve time at the end for questions submitted via the Q&A feature found at the bottom of your Zoom screen. So with that, we're thrilled to have alumna Jenny Gassman-Pines, class of 2006, as our presenter today. Jenny is an attorney at Green Espel and is one of the founding members of Green Espel's Diversity, Equity, and Inclusion practice. Jenny works with clients to develop proactive and incisive strategies to avoid litigation and disputes in employment relationships and to improve their workplaces more generally. As part of this practice, Jenny teaches award-winning trainings on unconscious bias, providing non-biased feedback, and fostering inclusion in the workplace. Welcome to Jenny, and I will turn it over to you.
Great. Well, thank you so much, Megan, and I'm really happy to be here. As Megan mentioned, there is the Q&A function on Zoom, and if you're having trouble hearing or having any tech problems, you can put your Q&A there because we do have the chat function disabled, so you won't be able to chat there, but I'll try to monitor the questions and either answer as we go or answer some questions at the end. I'll try to save a little bit of time. But I'm really thrilled to be here to talk today about the educational affirmative action decision that came out from the U.S. Supreme Court this summer, and other recent challenges to DEI programs that we've seen actually predating that affirmative action decision in the educational context and continuing into this fall. It's been a ton of litigation, lots of action in this area. So there's certainly a lot to cover today, but hopefully we'll have a good amount of time to get through everything. Just so you know where we're going today, I'm going to start just by level setting and being really frank about where I'm coming from, which is from a place of valuing diversity in the legal profession and thinking that it matters. And I'm going to talk a little bit about why it matters to our profession, just as a place where we can all start together. Then we're going to talk about the affirmative action decision that came out in the educational context this summer. You probably saw a lot of news about it. I'm going to go in depth in some of the language that was in there from the justices. And then we'll turn to looking at how we're anticipating folks will use the language from that educational context in both the employment context and in the context of business supplier agreements. Those are probably the two likely areas where we'll see challenges or where we have already seen challenges. And we'll talk a little bit about the impact of that. And in the context of those two areas, education and contracting, I'm going to talk about the lawsuits and threatened lawsuits that have already come out, both predating and postdating that affirmative action decision. So we'll start just with why diversity matters in our profession. Don't think it's going to be a huge shock to the folks who are on this call that the legal profession is actually one of the least diverse in the nation. Particularly as folks advance in private law firms. And when we look at judges, when we look at GCs of corporations across the country, our profession is just not that diverse. And it's unfortunate because actually the number of folks going into law school from diverse backgrounds is actually pretty high. We've got a lot of women who are going into and graduating from law schools. A lot of folks of color, a lot of people from different other diverse backgrounds. But unfortunately, as people progress in the legal profession, that just that ends, and it's been a pretty persistent problem. Something that we've been talking about, it feels like forever, and we're still talking about it. But why is diversity important? Well, it's important for a few reasons. One is because it really does promote confidence in our justice system. So not just in the courts, but in the system generally. When people see other folks in the system who look like them, they are more likely to believe in the legitimacy of the courts. And you'll see on this slide, we've got some quotes from Professor Sherilyn Ifill, who studies this. She's really an expert in this area. And as we all know, as law graduates, our system is only as good as the public confidence in it. And one part of that is reflecting the communities that we serve as lawyers, as judges, as folks who are advising people throughout the different areas of the legal profession and our justice system. Some people, though, need other reasons why diversity matters. We've got other reasons too. One of those reasons is that there's a lot of data and research out there that shows that diverse teams are just better. They focus, for example, more on the facts. They're able to bring different perspectives to the table, talk about those perspectives. They're able to consider then the facts more carefully and ultimately lead to better results. This is also true in the business context. There's lots of data out there that shows that not only are decision-making processes better and decision-making outcomes better, but also that businesses that are more diverse, it's better for their bottom line. They actually make a lot more money. So this is one of the messages that we give to organizations, particularly those organizations that are profit-driven, that actually diversity is good for their bottom line, that having diverse talent is really about having the best talent and finding the best people out there and making sure that they and their voices are at the table. So what does that look like in the legal profession? In the legal profession, I actually alluded to that before, and maybe that was a little bit of a Freudian slip when I used the word depression, because what we've seen are some things that are actually pretty depressing. So you might remember this Paul Weiss announcement, and I'm sorry to pick on Paul Weiss, but this announcement back in 2019 got a lot of play in social media when Paul Weiss announced their election of new partners, and this is what they looked like. They were almost all white men. There's one woman. And but they faced a lot of backlash, not just from the other lawyers and not just in the community, but also from law firms. And back then in 2019, 170 general counsels from different organizations in the country penned an open letter to Paul Weiss to say that they were very disappointed in this partnership class, that they didn't view the partnership class as reflecting our profession and wanted the law firms that they're hiring to do better. And so you'll see now, here's the theme, that was back in 2019, of businesses and general counsels saying, hey, law firms, you need to do better, and we're going to hold you to a higher standard, and we're going to expect that you have diverse teams serving us. So how did that recent educational affirmative action decision affect this type of messaging coming from general counsel and what businesses and other organizations are doing with respect to their legal services? So let's first just start about the decision itself that came out this summer. So just as a reminder, this was in the context of admissions programs at two universities, so at Harvard and UNC in Chapel Hill, where they essentially gave additional points to folks from diverse backgrounds. And those decisions in the context of educational affirmative action were challenged by an organization called Students for Fair Admission. And that organization challenged the admissions process and went all the way up to the US Supreme Court. And this summer, the Supreme Court's decision came out and said that universities cannot use race as a plus factor, that doing so in the context of affirmative action, in the context of these educational decisions, was unconstitutional and unlawful. And the basis for that decision was because it was based on stereotyping. And the court really looked at both the data, even in the context of the data around why diversity matters and having diverse groups leading to better outcomes. It still said we can't use race in this impermissible way. And Chief Justice Roberts, who wrote the decision, really focused in on the Equal Protection Clause and emphasized that race couldn't be used as a negative stereotype, as we see in sort of a more typical discrimination claim, but also may not operate in a stereotype more generally. And so what he was really focusing on was this idea of a stereotype, that someone of a particular race is now being evaluated based on their membership in a group, as opposed to their individual qualifications for admission into, you know, some of the most elite educational institutions in the country. And it according to Chief Justice Roberts, was really obscuring that individual decision-making process, obscuring evaluating each applicant on their own merits, and was instead giving them a plus factor based on their race. And he went on to say that college admissions are a zero-sum game. So when you admit some people, you are necessarily not admitting others, and that is, in a sense, a form of discrimination against folks who weren't getting those extra points based on their race. And ultimately, that the affirmative action in the education context was struck down. Now, what he did say is that universities can still consider an applicant's race in the context of their own personal individual experience. So they can talk about why their race or whatever other protected characteristic impacted their own character, their own experience, their own unique qualifications to be admitted to that particular educational institution. Now, how that language will be applied later, both in the educational context and in the employment context, remains to be seen. So stay tuned, but I think we're going to be seeing a lot more litigation about this. But at least there was this sort of, there was a little bit of a, yeah, we can't use race as a plus factor, but yeah, you can still sort of take it into account. But be careful of not stereotyping. So what are the potential impacts that we might see in the employment context? Now, first, just as a place to start here, on its face, the educational decision was only about admissions to educational institutions. It was not about employment. They were not evaluating Title VII or any other state's employment laws. And I say that because it's really important to remember that in the employment context, employers were already prohibited from using race or other protected characteristics as plus factors in hiring. You already cannot do that under Title VII. You already cannot do that under the Minnesota Human Rights Act. You can't make decisions based on an individual's race. You can't give someone a plus factor because of their racial background. And in the educational context, that was a different framework where the Grutter v. Bollinger decision that the court essentially overturned allowed that plus factor to be used in the educational context. Well, you can't do it in the employment context anyway. What we do, however, have in the employment context are mandatory affirmative action programs for government contractors, and those are highly regulated and managed by the OFCCP. And then we also have permitted voluntary race-conscious affirmative action programs. They're permitted under Title VII, but I will say that voluntary race-conscious affirmative action is much less common. It's much riskier for employers because they are taking race into account, but it is permitted as long as it's remedial in nature, designed to eliminate a clear imbalance in traditionally segregated job categories, and it can't hinder the employment prospects of non-diverse candidates, and it also has to be temporary. So there's the framework of mandatory affirmative action. There is this sort of gray area of voluntary race-conscious affirmative action in employment. And then there's really the area of voluntary programs that a lot of employers have been putting in place that I'll put into the bucket of diversity, equity, and inclusion programs. But aside from those mandatory affirmative action programs, employers are really not permitted to take race into account in that individual decision making. So in the wake of that educational affirmative action decision, the EEOC, which is the government organization that regulates employers and enforces Title VII, the EEOC came out with a statement about what does that decision mean in the context of our job as the EEOC of enforcing Title VII. And it made clear, just like I said before, that that decision didn't address employer efforts to foster diversity and inclusion. And the EEOC, as of right now, at least under the current administration, is still saying as a policy statement that it is lawful for employers to implement diversity, equity, and inclusion programs as long as they are seeking to afford workers equal opportunity. So in that bucket of voluntary DEI programs, the EEOC says those are permissible. We are still all about opening doors to folks, making sure that they can get access, that they can still get employment, and that our employers and our workforces are really reflecting the communities in which we live. So what about other lawsuits and legal threats? So I know this slide has a ton of information, but I'll just point out a few things about it first. As you can see, actually, all of the cases that are on this slide predated the Educational Affirmative Action Program. I think that's an important point because the U.S. Supreme Court's decision this summer caused what I'll call, using a technical term, like a freak out. I think people were obviously rightly very concerned about not only what it meant in the educational context, but how corporations, public sector employers, how other employers were going to respond to this decision. But the reality is that there were legal threats to a lot of the diversity work that employers had been doing already, even before that employment decision. So you can see some examples here of lawsuits by organizations that are challenging internship programs, programs that were trying to increase diversity, and the tactics that these organizations are taking to challenge the diversity programs has largely been through using Section 1983. So I'm sorry, Section 1981, and some of them have been through challenges based on shareholder status. Those have tended to be less successful, but they're still out there. And they are certainly in the spotlight of organizations that are trying to dismantle diversity, equity, and inclusion actions. In the wake of the educational decision, we also, in addition to these lawsuits, saw what I'll call the battle of the Attorney General letters. So first, many employers got a letter from attorneys general of certain states that had a rather threatening tone, and were telling employers, hey, even if you label something as diversity, equity, and inclusion, if you're discriminating, that's not okay, and we're going to come after you. Those were largely, or maybe entirely, letters from attorneys general in Republican attorneys general. Then we have the next letter that followed, coming from Democratic attorneys general, who said, we've reviewed that letter and we disagree. And of course, we don't want companies to engage in racial discrimination, but we think the DEI work is still very important and you should continue to do it. So it remains to be seen exactly which attorneys general are going to actually bring lawsuits. But of course, the decision from the summer certainly put a spotlight, an even stronger spotlight on the DEI efforts that are going on across the country. And what about lawsuits against law firms? So we've seen a number of those this summer. At the end of the summer, an organization filed a lawsuit against Perkins Coie and Morrison and Foerster. Those were kind of the first two splashy lawsuits against law firms trying to challenge their programs for summer associate hiring. So Perkins Coie and Morrison and Foerster both had diversity clerkships, where they had clerkships or summer associate positions for individuals from diverse backgrounds. They were limited to folks based on their diverse backgrounds, and this organization sued to challenge them. Interestingly, Perkins Coie, after being sued, actually, I wouldn't say they dropped their program, but they agreed to permit all law students to apply to their diversity fellowships, not just members of historically underrepresented groups. And they issued a statement saying that they were committed to building a more diverse and inclusive workforce, and that commitment remains steadfast, despite backing away pretty quickly from their diversity clerkship. Haven't yet seen what Morrison & Foerster is doing, and so I think that lawsuit is actually still active. And then most recently, just about a week ago, same organization sued Winston & Strawn, another huge law firm, related to its fellowship program. And this fellowship program is actually through the Leadership Council on Legal Diversity, which is a legal diversity organization that many law firms and corporations are members of, with the goal of increasing diversity in the legal profession. I think it's probably not lost on most folks that these giant law firms like Perkins Coie and Morrison & Foerster and Winston & Strawn are not exactly bastions of diversity, particularly as you get up into the most senior levels. I mean, that's true just across the board, particularly in private law firms, particularly in the biggest private law firms, although they have fairly robust diversity programs to bring associates in. They tend to have a harder time with retention, as we all do across the legal profession as folks advance. So it's interesting to see then the challenges happening at that pipeline level, at that associate or summer associate level, when we're not really seeing that retention go throughout. So what does this mean for law firm hiring? What does it mean for summer clerkships, and how are each of these law firms going to respond? You know, I think that a little bit remains to be seen. We'll see which organizations decide to double down on their commitment to diversity, on their programs, and which ones decide to alter them in the face of lawsuits. For those of you who are still local here in the Twin Cities, Twin Cities Diversity in Practice issued a statement after the affirmative action decision came out and said that, you know, after careful consideration, it was not altering its diversity summer programs. So, you know, we're seeing different reactions from different organizations. There's that, you know, Twin Cities Diversity in Practice versus what Perkins Coie did. We'll continue to see how this all develops. But I think at the bottom, what it is going to mean is that employers, including law firms, including legal services organizations, we are all going to have to think about how can we recruit diverse talent, how can we hire diverse talent in ways that are consistent with Title VII and consistent with the language that we were seeing in the educational affirmative action decision. So what are ways that we can reduce the risk in our hiring and still open the doors and still make sure we're recruiting the best talent, which is necessarily going to be the most diverse talent. So I'll just highlight for you some of the things that we're seeing based on the legal challenges and based on the affirmative action decision in the educational context that are that I'd put in the riskier bucket, right? The areas where if you're doing as an employer, that might open you up to more legal risk or open you up to be the target of the next lawsuit by the organizations that are trying to dismantle some of this diversity work. So for example, reserving certain spots or reserving promotions for certain particular underrepresented groups. That's going to be a higher risk activity and one that's likely to attract more attention. Talking about doing those things externally also going to be likely to grab more attention and open the organization or the employer up to a little more legal risk. Instructing managers to use race or sex as a tiebreaker when choosing between candidates. This is an easy one that, of course, it's going to open you up to more risk, and of course, it's going to be evidence in a future lawsuit. It's one where you need to be super disciplined across your organization about what your expectations are for hiring, that you're not taking into account race or other protected characteristics when you're making individual hiring decisions, because that's not permitted. And, with 2 equal candidates, you have to decide on something other than that protected characteristic. You can't use that as a tiebreaker. And if you do, it's obviously much riskier. Setting strict demographic targets or quotas and tying those to compensation or other penalties. I think this is an area where we're going to see lots of discussion, because many employers throughout the country, particularly in the wake of George Floyd's murder, really put out public statements, not just about their commitments to diversity, but also to their commitments of meeting certain goals of representation and mirroring their communities. I personally think that a goal is very different from a quota, but being able to articulate what a goal means and being able to articulate why it's a goal instead of a quota, I think will be important to organizations in terms of how they can reduce risk, particularly in light of the affirmative action decision. And one thing I think any employer can do is think about auditing their DEI programs and making sure, okay, do we have a discipline of message here? Are we really talking about our diversity efforts in ways that make sense and that are consistent with the law and that are reducing those risks? So ways that you can reduce risk, or things that employers can do that are less risky, is go from the idea of from cohorts to concerns. So expanding programs for particular demographic cohorts and thinking about how you can open the doors to everyone, right? So it's about opening doors as opposed to closing them off, including for folks who are from diverse backgrounds. Shifting how we talk about DEI efforts. So considering talking not just about diversity, but about de-biasing. So identifying parts of our process that we can tell are actually creating bias. So why do we only have white males in our partnership class? What was it about our process that led to that outcome? And now how can we change that process? So as opposed to saying, well, now we're only gonna promote women to that partnership level, think about what was in place before that led to only white men getting to those promotions, getting to that level, and eliminating those barriers. Switching from numbers to narratives. So focusing less on those numerical goals and instead focusing on individual narratives and individual backgrounds. Now, I'll be super clear. I'm not saying that organizations shouldn't have goals and that organizations shouldn't measure their success. But I do think that having narratives and having discipline around language when you're talking about what those goals mean can also help reduce risk and kind of pull that spotlight off of the organization. And then thinking about, from unique to universal. So focusing less on unique programs that are aimed at addressing specific concerns, and all thinking about, okay, how can we foster a culture that's open and welcoming to everyone, so there's a sense of belonging for everyone. Now, there may still be programs that are targeted at diverse populations because they might have different needs within your organization, but thinking about how you can structure that to make the doors open for everyone and inclusive for everyone versus exclusionary. Okay, so what about supplier programs? So this, and by supplier programs, I mean programs by organizations to, when they're hiring services for themselves, that they're trying to increase diversity among the folks who they hire for their contracts and for their partnerships. So like Title VII, Section 1981 prohibits discrimination in contracting. So that legal framework already existed before the educational affirmative action decision of this summer. There are fewer lawsuits in the 1981 context than there are in the Title VII context. And that may just be because I'm just guessing here, but I think companies that are trying to gain contracts are maybe less likely to sue the entities that they're trying to do business with than individual employees are. So there's certainly a robust legal framework and lots of case law of individual employees suing, a little bit less in the 1981 context. But this really has been an area of focus that we've seen, particularly for organizations that are trying to dismantle some of the DEI work that companies are doing. And, my guess is that future challenges are really going to pick up on some of the language that the Supreme Court used in the educational context and apply it to the contracting context, particularly this notion of a zero-sum game. And frankly, that it can apply to hiring as well. But, look, if you only have X number of dollars that are going to go to your outside contracting, and you're reserving a certain number of dollars for one group of people versus another, then that zero-sum game language from the educational decision, one could argue might apply there as well. So we are also seeing legal challenges based on this idea. And again, I'll just point out that some of these predate the affirmative action decision of the summer. So that Amazon case, that was before the affirmative action decision came out. The case that has probably gotten the most press recently is the Fearless Fund lawsuit, and it's been all over the place. It's a lawsuit challenging grants that were given to businesses owned by Black women. And the case is very much about the First Amendment right of the organization to give out grants to the organizations of its choosing versus the anti-discrimination laws, and in particular, Section 1981. So initially, the district court denied the request for a preliminary injunction, said plaintiffs are not likely to succeed. These grants can keep going. There was a super fast appeal to the 11th Circuit, and the 11th Circuit reversed and actually said, for now, yep, the preliminary injunction should be granted. And so there is an injunction right now on the grants for businesses owned only by Black women. Now, of course, this lawsuit just got filed in August, and certainly it's going to progress. We'll see if there's an ultimate decision either at a summary judgment stage or ultimately through a jury trial. But I think we will continue to see this case go up again. And ultimately, it has the potential to go all the way to the Supreme Court, and we'll see then what the U.S. Supreme Court says about it. So how does this work in the law firm context? Well, there have also been challenges, or at least threats of challenges to companies for their law firm hiring. So many companies have started programs where they would require law firms in their preferred networks to have a certain number of hours worked by diverse attorneys, or to have a certain number of arguments done by diverse attorneys, that type of thing. And organizations have threatened to sue over those as well. So there are a couple examples here. The one I think is kind of interesting is the Coca-Cola legal supplier agreement, which after they announced that they needed at least 30% of billed attorney time to be done by diverse attorneys, after they were threatened with a lawsuit, then they came out publicly and said, actually, you know what, we never implemented that policy, and it's not a policy that we have. And so, I think it's going to be really interesting to see how organizations balance between the threats of lawsuits and the language being thrown around by people bringing the lawsuits that tie back to those affirmative action decisions, and their commitments to their diversity programs and how they think about it. But it certainly is going to require, not just in the employment context, but in the contracting context too, different organizations to think a little bit differently about diversity, equity, and inclusion, and to think about what can we be doing, again, to open those doors and to reduce the barriers, rather than to give plus factors, because I think the writing's probably on the wall in terms of how the U.S. Supreme Court is going to come out, at least in its current makeup, about sort of how it values these plus factors together. So also in the context of the contracting, there are really things that that companies and public sector entities can do that are riskier, right? So reserving business for certain contracts for contractors of certain races. So doing things like the law firms did, requiring particular demographics of individuals who work on your projects. Thinking about having strict targets or strict quotas for the amounts of dollars you're going to spend with particular organizations or organizations that have certain demographic makeups, setting penalties for that type of thing. Each of those things are going to be riskier, partially because they're just in the spotlight more. And folks are really focusing much, much more heavily on what organizations are doing. But what can you do that's less risky? Well, this is similar in the contracting context than it is as it is to the employment context. So thinking about expanding programs to expand access. So in the contracting world, for example, thinking about, okay, you only have used XYZ businesses in the past. Well, how can we make sure that other businesses know that these contracts are out and are available? What do we need to do to change our RFP process to bring in additional contractors who you might not have otherwise known? Think about where you can recruit those organizations, how you can open the doors and make sure that then you're getting folks into the pipeline and making sure that those contracts are available to everyone. Thinking about also what are the outcomes here and how can we alter our processes to level the playing field and to eliminate those biases that might be inherent in our system, and to really think about and do the work of why are all of our suppliers, why do they all look the way that they do? What can we do to really increase the diversity of our suppliers? So, for example, in the legal context, how can businesses, public sector entities, legal services organizations, how can we help create that pipeline of folks who might be interested in being lawyers? And it may start even well beyond law school, right? Think about going into high schools, going into the community, educating members of the community who might not otherwise know, what do lawyers do? What does it take to become a judge? What does it look like to be a lawyer, but not a lawyer who works in the courtroom, right? So help educate folks who don't necessarily have lawyers in their lives, learn what lawyers do, and encourage them to go on to college and go on to law school. So now we've broadened the net of folks who might choose to be lawyers who otherwise wouldn't have been available to us. Again, sort of similar with employment, move from numbers to narratives. So thinking about how can we eliminate those processes? How can we talk about righting wrongs versus just increasing numbers? And then lastly, again, this sort of from unique to universal, focusing less on those unique programs that are aimed at specific demographics, instead thinking about how can we open the doors universally. So I know that was a lot of information, but we do now have some time for questions. And I will start with the first question that I got from the Q&A. So just as a reminder, if you want to just click into there, if you have a question, I'll then read it and try my best to answer it. So the first question is, how risky is a policy statement such as we strive to reflect the communities we serve? So I personally think that that's actually not a particularly risky statement. It's a pretty broad general statement about aspiring to reflect our communities. It's pretty hard to argue with striving to reflect the communities that we serve. And it's also not directly tied to any particular individual decision that an organization may be making, whether it's an employment decision or a contracting decision. So that to me is a pretty general statement that is one that is pretty safe. Now, how could we change that statement to make it riskier? Look, you could say we strive to reflect the communities we serve by having X% of our employees be X characteristic. That's obviously a much more specific goal. But just because that goal is specific and just because it's an aspirational statement, it doesn't actually mean that that it's illegal or that there's anything wrong with it, or that it will ultimately be struck down or something like it will be struck down by a district court or an appellate court or the U.S. Supreme Court. And part of that is because having aspirational goals is not necessarily going to be evidence in an individual lawsuit, whether it's an individual discrimination lawsuit or an individual lawsuit brought by an organization that's trying to challenge certain contracting relationships. Certainly, I think we can anticipate that organizations are going to use those types of aspirational statements as evidence. But really, when you're defending a statement like that, I think part of the onus will be on the organization to articulate why it's aspirational, what makes it different from a quota, why it's not mandatory, all of those things that you would argue in any type of lawsuit when you're arguing about what is the meaning of a statement. I also think it does, I think, reveal an example of what you want to be thinking about too in terms of discipline across your organization in how you talk about the diversity goals. So for example, saying something like we strive to reflect the communities that we serve, also being really clear that you expect that individual decision making does not involve, and you have prohibited discrimination. You don't want employees or other members of your organization to get the idea that because you are striving to reflect the communities that you serve suddenly means that they should throw out the HR rulebook and just start hiring based on impermissible factors. So it may be that sometimes your external statements need to be coupled with internal statements that explain what your rules are for hiring, what your policies are, and how folks should be making decisions. This, I think, becomes even more important if the aspirational statements or policy statements that you have are tied to particular numbers, so that individual employees don't get the wrong idea of, oh, my employer is measuring me against this goal, so that means I need to fudge the numbers or do something that I otherwise know is probably prohibited. So you want to make sure that you have some of that discipline across the organization, that you're really talking about, look, what can we do to eliminate bias in the system, to eliminate bias in our hiring processes that are going to help us reach those goals, as opposed to let's just give a plus factor to an individual person because of their race. That's not how you want to reach the goals. And so you want to make sure that the people within your organization really understand that. Okay, next question. What if I said we want to recruit and hire people from a particular geographic space? So if we strove to hire people who graduated from HBCUs, which are not demographically all African American individuals. So I think that is, I think that's actually a great example of something that organizations can do in the recruiting context to help open the doors. And I say that because encouraging your recruiting folks to go out and look at places where they might not have looked is a way to get people in the door. And it doesn't mean that just because you're recruiting at historically Black colleges and universities that suddenly you stop recruiting at other universities. It means that actually you're expanding your pool of applicants to make sure that the processes you had in place before weren't eliminating people because you just weren't thoughtful about it and you weren't thinking about it. So recruiting at HBCUs in the context of doing all of the other recruiting that you're doing, I think, is a really great idea. And it's also a way to think about, I think that the affirmative action educational decision obviously got a lot of focus. there was a great article in the New York Times not that long after it came out about how the most elite institutions like Harvard and the Ivy League schools, they actually are less diverse than the vast majority of other colleges and universities across the country, let alone the HBCUs, right? So that if organizations are only recruiting, for example, from the Ivy League, they're missing out on a whole group of other people, of amazing talent that's across the country that may not have been able to access the Ivy League for all sorts of reasons. And they also are more likely to be diverse just by virtue of the demographics of those institutions. So I think it's a great way to think about, all right, well, maybe we need to test our assumptions, and test our processes. And by eliminating some of the things that we've always done without thinking, that actually we're going to expand our doors and increase our diversity pipeline. Another sort of add-on to that was focusing on recruiting from folks who grew up in redlined neighborhoods. So again, I think the focus of providing access to folks who otherwise may not have access, that's a very low risk thing to do. It's not making a decision based on where someone lived, or an assumption or a stereotype about what their experience may be, but it is opening the doors to folks who otherwise the doors may have been closed for all sorts of reasons, whether it was explicit racism or racist policies like redlining, to the unconscious biases that may result from folks living in those neighborhoods and growing up throughout their lives. Okay, next question. As you work in this area, do you ever get questions as to how to make a workplace one that a diverse workforce would be open to joining? And so that's a great question. So how do you make your workplace one where folks from a background that may not be the same as yours, that those folks want to work there? So I think a piece of it is about how you communicate, how you're opening doors, and how you're making folks feel welcome. A piece of it is once you start building on diversity and belonging, and you have a group of folks who feel like they are engaged, and they are valued and they can advance, then it has the potential to really snowball. So how can you do that? How can you create an environment that is open to folks who may not have been open, who may not have otherwise had access? I'll do a shameless plug and use my organization, my law firm Green Espel, as an example. I actually give a huge amount of credit to the founders of our firm because they had a vision for what our law firm could be like, and part of that vision was creating a law firm that was different. And the way that we're different is that lawyers from day one, it's one lawyer, one vote, access to all of the information about the whole firm, all of the financial information. We vote on each other's compensation. We learn the business of the law right from day one. That vision is one that I think has helped us as an organization recruit lawyers who are racially, ethnically, religiously diverse, because from day one, they're on equal footing with our named partners, and really feel like they have a voice and a place at the table. And then we have, of course, work to do to make sure we're also giving people interesting work and helping them advance as lawyers and advance their careers, no matter who they are. But thinking a little bit differently about how your organization is structured and bucking their traditional model, I think can be a great way to make folks feel like, oh, this is a place where even if people don't look like me initially, this is a place where I want to go. And then you can use that to continue to build diversity in your organization. But I think now there's a huge focus too on the sense of belonging. So it's not just enough to get people in the door. But you have to figure out, all right, how do we keep people here? People of all different backgrounds. And part of that is, like I said before, giving people interesting, good, challenging work, making them feel valued and part of the organization, giving them really good feedback, feedback that then can help them live, expand their career and really grow as lawyers. Those things are what help people stay when they feel valued and feel part of a community. And I think that's a lot of the work that we have to do, particularly in the legal profession right now, is once we get people in the door to help them want to stay. Because as this whole group knows, it can be really hard to be a lawyer, and particularly for those folks who are still practicing. This is not an easy job, and you want to be somewhere where you feel valued, and that's a big part of how you get people to stay. Okay, I see one last question. Okay, so this question actually goes back to the idea of what if we focus on hiring from HBCUs or hiring from folks who are from red line neighborhoods? I think, and then the question is now, what if we said we would break a tie based on our goal to have people from certain red line neighborhoods? I think this is probably getting into more of a gray area of risk, only because the question is like, well, are you using red line neighborhood as a proxy for race? And maybe you're not, but how are you going to, as an organization, articulate what it means to be from a red line neighborhood? Because red line neighborhood in and of itself, it's not a protected characteristic under Title VII. Under the Minnesota Human Rights Act, and obviously folks from all different backgrounds can live in neighborhoods that had historically been redlined. And so, I think being able to articulate why you're doing that and making sure that you don't have folks who are talking about redline neighborhoods as just a shorthand or a proxy for race is a way to reduce the risk. So it's certainly not something that is, that any court has said, no, you absolutely can't do this. You just want to think about how can you structure it to maybe reduce some of the risk and increase the discipline around how you're talking about the decision-making process. So let's see, I think we might have, all right, we might have time for one last question if anyone else has questions. Otherwise, if you don't, thank you so much for your time today. I hope that this was informative and engaging, but also if you don't feel comfortable asking questions through the Q&A, I'm happy to take questions separately. If you want to just shoot me an email, I have a very Googleable name, and Greeness, you can Google that too, and my contact information is right on the website. So thank you so much for joining us today, and I'll kick it back to Megan, who I know had just a few closing remarks before we all sign off.
Yeah, thank you so much, Jenny. We really appreciate you sharing your time and expertise with us today and being our first ever Alumni Network CLE presenter. So thank you. And thank you to the attendees for joining us. And just please keep an eye open for other opportunities hosted by the Alumni Network.